Proposition 8, California's ban on same-sex marriage, was overturned Wednesday in federal court. Judge Vaughn R wrote in his ruling, quote, Proposition 8 both unconstitutionally burdens the exercise of the fundamental right to marry and creates an irrational classification on the basis of sexual orientation, unquote. Proponents of Prop 8 have appealed the ruling to the U.S. Ninth Circuit Court of Appeals. David Rolland, editor of San Diego City Beat, joins me now to analyze the story. David, how surprising was Judge Walker's ruling to you?
It was not surprising at all. I don't think it was surprising to a lot of people. I think even the people who don't agree with the ruling, the defendants, I guess, or the proponents of Prop 8 weren't, I think, expected this outcome. And really, the judge's ruling matched what my newspaper has been saying all along, and that is that this is a simple matter of equal rights and equal protection under the law.
But it did not match what the majority of people in California said in 2008. 52% of them approved the idea of banning same-sex marriage.
Yeah, I think we're at a critical fulcrum in this debate where public opinion is gradually changing. I wish it would happen a little faster, but we're right there sort of on a 50-50 level, and I think over time, as older people die off and younger people take hold with their attitudes of tolerance for homosexuals in this society, I think it'll change and it'll be done with in a matter of time.
So this is generational.
I believe so, yes.
Okay. Well, we asked San Diego City Councilman Todd Gloria, who's a proponent for gay marriage, to respond to Prop 8 supporters who say Judge Walker's ruling has short-circuited the democratic process and invalidated the will of the people.
You know, it is true that the public weighed in and a majority chose to support marriage discrimination. But I think what the ruling yesterday shared is that the rights of the minority should never be up for a majority vote. And that in particular, in this situation, the judge found that in no way are straight people harmed by gay people's ability to get married. And so if we use the same principle that is applied in Prop 8, we would not have seen great progress in this country. You know, the women's right to vote was not terribly popular when it was initially proposed. You know, desegregation, not very popular when it was proposed. But we have seen the courts time and again side on the cause of social justice to say, we will not allow the majority to disenfranchise the minority. And this is just yet another example of that.
And yet there are those people who say that this ruling undermines the democratic process. You have majority rules, don't you?
No, fortunately not in this country. We have a series of checks and balances. The different branches of government provide checks and balances on one another, and the court system, fortunately, provides a check on majority will. You cannot just say put anything to a vote in this country and just say whatever the majority says goes.
All right, let me read you from a letter to the editor in this morning's San Diego Union Tribune. Why should the public take the time and energy to vote for any amendment when the end result will come down to the opinion of one man or one woman? Meaning the judge. How do you answer that?
Well, this wasn't really just a matter of one man's opinion. This was a trial that played out. It was a process where one side presented arguments and the other side presented arguments. And the judge in this case made a series of meticulously crafted findings of fact based on the evidence that was presented in trial. And it was his ruling, his conclusion, that one side overwhelmed the other side in terms of scientific factual basis for a ruling.
But then there are those who say that his rulings were actually laying the basis for this case to go to the U.S. Supreme Court. And the U.S. Supreme Court now is considered more of a conservative court. So is that a good thing for the proponents of eliminating the ban on same-sex marriage?
Well, we'll see. I don't know. I'm not an expert on the U.S. Supreme Court, and I wouldn't want to predict how they would come down on this. But I will say that the most thoughtful analyses that I've read about this ruling is that Judge Vaughn Walker had Supreme Court Justice Anthony Kennedy, who's considered a swing vote on the court, had him in mind, and Kennedy has given his own opinions on civil rights issue, including the sodomy law in Texas that was thrown out. I think he was a crucial judge on that ruling. So what I've read is that Walker really had Anthony Kennedy in mind, and I think it's smart for him to. He doesn't want his opinion overruled by a higher court, so it's smart to really lay out a case. And this was 136 pages worth of meticulous thought.
It's going to be one of those fascinating things to watch. Thank you very much, David Rolland.
You're welcome.